Hello everyone, welcome back to my legal philosophy channel. My name is Constance Lee and today's video is titled The Enduring Influence of Legal Positivism. And so what we aim to do in this video is to consider the central tenets of legal positivism as one of the dominant theories in jurisprudence at this time, then consider the theoretical development over the last 200 years, and then finish off by examining some of the lasting influences that this theory has had on the intellectual legal landscape and the culture more broadly, because law is such an indispensable part of social life. For those who are still studying law, it is a theory that your jurisprudence lecture will probably spend the most time on. You may even attend a law school that does not have jurisprudence as a core subject due to the abiding effect of legal positivism as a theory. Let's start by considering some of the key tenets of legal positivism before we embark on this journey to look at the development of legal positivism. And some of the seminal theorists associated with the development of this particular theory are Thomas Hobbes, and he lived from 1588 to 1679. We have David Hume, 1711 to 1776. We have John Austin, who is known as the father of legal positivism, who was alive from 1790 to 1859, and HLA Hart, who is probably the most seminal scholar in this area in the last century, so 1907 to 1992. And so for those of you who are not studying law at this time, you'll probably find that this is going to be a more technical video. So feel free to let the jargon wash over you, but probably just keep in mind some of the key points so that you can still be present for the discussion at the end when we consider some of the conceptual implications of legal positivist theories on the present culture, as well as assessing some of its enduring legacy for the study of law and legal practice more broadly. Okay, so let's begin with definitions. What is legal positivism? So the first word is pretty simple: legal, relating to the law. The second word is less intuitive and probably more significant for our examination today, and that is positivism. This is a noun derived from a verb, which means to posit. In other words, lay down, to enact, or to establish by some authority. Okay, so as a system, positivism alludes to a theory that recognizes only something that is scientifically verifiable, provable by logic, and it rejects anything that's metaphysical or theological. And we'll return to this point later, but for our present purposes, positivism is about someone, a human being, positing something, laying down something, enacting something, establishing something. All right, so by this formulation, legal positivism holds that the existence and content of law is not dependent on its moral status, rather it's dependent on something else. So on this view, law is simply the collection of social rules recognized as binding within a given community at a particular time. If the legitimacy of law does not depend on moral substance, then what is the validating factor of law? And the positivist will answer that the only thing that categorically validates a law is its sources, right? We just talked about the verb to posit. So the person who posits has to be a legitimate authority for the law to be considered valid in legal positivism. So this is known as the sources thesis, which is fundamental to the theory. It is also worth noting here that natural law theorists don't deny the relevance of sources in the determining of legal validity, but they do believe that it is just an additional factor, so it's supplementary to the moral test. And a useful analogy might be that natural law theorists believe that morality exists like an aquifer under the surface, and that the human-made or posited law, which also exists on top of the surface, must connect to the aquifer first in order to be considered valid. Also note that positivism exists on a spectrum. So there are exclusive to inclusive legal positivists. Now, exclusive or hard legal positivists posit that the existence and content of law should depend solely on the sources, whereas inclusive or soft legal positivists concede that in certain legal systems, moral standards should be incorporated into the test for legal validity, though they have a very impoverished view of what morality constitutes by saying that it's socially recognized norms, etc., not necessarily objective values or transcendent norms. All right, so legal positivism is a school of analytical jurisprudence which emerged in the 18th and the 19th centuries. As such, it's a relatively modern development in legal theory. As you can see from the chart on the screen, natural law theory can be traced back to classical Greek times and even before that. And you see the remnants of that from 2,000 years ago. And it was recently revived thanks to a group of Thomistic scholars, namely John Finnis and Germain Brisset, as well as Robert George. But the dominant theory in jurisprudence in modern times is legal positivism. Right, so let's have a look at some of the precursors of legal positivism, those who brought about this dominance of legal positivism in the present times. So Thomas Hobbes has famously argued in his book, The Leviathan, that human life in pre-legal state of nature would be nasty, brutish, and short. And so in order to escape the state of nature or this reality, people would be justified in agreeing to cede or grant sovereign power to a centralized authority, which he named the prince, which would provide protection in return for this obedience. And Hobbes is often miscategorized as a natural law theorist due to his emphasis on the state of nature. However, this is a pretty big misconception. As you'll see, Hobbes is a naturalist in the sense that naturalists refer to the law that science aims to describe, whereas natural law refers to the school of philosophy that holds certain values as rooted in human nature, but based on an ideal end. And it holds that the legitimacy of law necessarily depends on its moral content. The position of Hobbes' naturalism and natural law theory are thus logically independent. So Hobbes' naturalism identifies human nature completely with the baser animal instincts or physical needs that are required to survive for survival purposes. And in this context, human is like wolf to another human, as the famous Latin adage goes, homo homini lupus. And in this descriptive context, in this realistic context, Hobbes' legal theory normatively requires humans to rule that nature in order for survival. So I think that basically his end value, his only ideal really, is survival. The next famous scholar to consider in the context of legal positivism and setting the groundwork for that is David Hume. And David Hume is best known for advancing his famous argument that moral judgments have no rational basis. And his criticism of some moral philosophers was based on the fact that he believed they fallaciously derived moral conclusions from purely factual premises. And this has been widely accepted and is known as the Humean guillotine, which is categorized as a logical fallacy. What legal positivists later did was to leverage this distinction to argue that what a law is and what a law ought to be are two separate questions. For example, that famous natural law statement or maxim, lex injusta non est lex, an unjust law is no law at all is often attributed to St. Augustine, who was a natural lawyer in AD 300s. But on the face of it, the statement appears to violate Humean guillotine, or the separation fallacy, because he's basically claiming that an unjust law is no law at all. So what a law is not what a law ought to be. So he's seemingly conflating is and the ought. On this point, Professor Jonathan Crowe makes a brilliant argument to raise the possibility that legal positivist argument is fallacious themselves. He uses the analogy of the koala bear to make this point. He notes that the same two words are often used to convey two different things. In fact, in linguistics, a word for that is called a homonym, right? So a koala bear is no bear at all, is not logically fallacious. It still makes sense. Though a koala is colloquially known as a bear in strict zoological terms, it does not belong to the bear family in the technical sense. So for those who are interested, the bear family is Ursidae, and koalas belong to the Phascolarctidae family. I have no idea how to say that, but for those who are interested in zoology, there it is. In any event, what Augustine was meaning when he was using the word law was two different things in the first and second sense. And he means that a law nominally so called may still not be legitimate law as it does not pass the necessary moral test. All right, so now we get to the scholar who is widely known as the founder of contemporary legal positivism, and that's John Austin, who lived from 1790 to 1859. And John Austin was strongly influenced by the work of Jeremy Bentham, who would be quite a familiar name, 1748 to 1832, who was a leading utilitarian theorist. So Bentham was heavily involved in social activism, and his normative thesis derived from the statement that is pretty well known today, the greatest happiness for the greatest number. This maximizing principle is what it's called, has had an enduring influence on modern culture and is associated with the emphasis on functionalism we see all around us today. So Austin's command theory of legal positivism. In this theory, Austin defined law in the strict sense as a command of a sovereign backed by sanctions. So in order to identify law according to Austin, it must possess those three key features. It must take the form of a command. Any violation of a command must attract a sanction or punishment, and it must emanate from a sovereign. So Austin observes that a command originates from a desire by the sovereign to bring about a certain outcome, and the desire is then signified or expressed, and the signification of the desire gives rise to a duty or an obligation on the part of his or her subjects, and this duty is enforced by means of sanction. So a punishment is imposed if the command is not followed, and people habitually obey the sovereign out of fear of punishment. And so Austin argued that the sovereign is distinguished by two key characteristics. The first is a positive mark of the sovereign, which is that the bulk of the people out there habitually obey it. And the negative mark of the sovereign is that it does not himself or herself habitually obey any other authority. In addition, Austin described the sovereign as continuous, indivisible, and illimitable. Now, there are a few objections to Austin's theory of failing to cover certain types of law. For example, constitutional law is not law according to John Austin's legal positivism, since the sovereign is limitable here. If he insists that the sovereign must be illimitable, constitutional law is not a law, because constitutional law's main purpose is to place limits on the sovereign. Similarly, international law is not a law, according to Austin's theory, since there is no identifiable sovereign. Same goes with customary legal systems, such as indigenous legal systems, will not be considered a law as they do not need the endorsement of a sovereign command. However, Austin holds that common law is a law, since judges act as delegates of the sovereign. That's open to debate. So HLA Hart, who succeeds Austin, is the most prominent legal positivist of the last century. He establishes his theory on the contention that Austin's concept of command fails to recognize the law is comprised of social rules. So he says that Austin's failures probably because of his oversimplistic definition of what law is by only looking at it in terms of the sovereign and his subjects instead of looking at it in terms of society as a whole. And Austin's idea of sanction fails to recognize that different types of laws attract different remedies and not all are punitive. So he's saying that because he's oversimplistic in the definition that there has to be a punishment, he forgoes many aspects of law that actually don't have any punishment associated with it at all. For example, what about contract law? That two people enter into a contract willingly, and not all breaches of contract will result in a punishment by the sovereign. In many legal systems, it's difficult to identify a sovereign as well. For example, in Australia, nobody enjoys unlimited authority, being that we have accepted the constitutional doctrine of separation of powers. And the very idea of the sovereign in every circumstance generally seems too rigid. So this brings us to HLA Hart. And his most seminal work, his magnum opus, we could say, is The Concept of Law, which was published in 1961. Now, he contributed probably the most influential aspects to the particular philosophical framework in this century, and he brings a sociological insight to positivist theory. So Hart is what we call a soft positivist, and he holds that laws are rules made by humans rather than one human. However, the traditional legal positivist view in this light, according to him, was oversimplistic, and laws are validated by humans as part of a broader social culture as opposed to being the product of a single human being. So his legitimating test for assessing whether the rule is a law, he coins the rule of recognition. And the rule of recognition is a legal test recognized by judicial precedent or the legislature. So it's recognized by a few officials as being the relevant test for determining whether something is a law or not. And so given the sociological focus, that's why Hart is called a soft positivist as opposed to a hard one. And he's soft in two ways. The first is by the practice thesis, and the practice thesis basically holds that law exists in the society as a matter of practice. The morality thesis is the second part, that moral standards can be taken into account legitimately within the discretion of the courts in applying the law due to the rule of recognition, which is that social test. All right, so how does Hart answer the question of what is a law? First, he asks what perspective we should adopt in analyzing law. And second, he asks, do we need to ask what definition of law we arrive at by adopting the relevant perspective? So Hart criticizes early legal positivists, particularly John Austin, for not addressing the first question adequately. And he argues on that point that the correct perspective to adopt in understanding the concept of law is what he calls the internal point of view. Hart contrasts the internal point of view with the perspective of a purely detached observer, such as a Martian. He calls this the external point of view. He argues that only by considering the internal point of view of the subject can we properly understand obligation. And this is central to the concept of law. As we touched on earlier, Hart clarifies the crucial idea of having an obligation by distinguishing it from the notion of being obliged. So he says basically, Austin's theory is oversimplistic because he says that we obey the law habitually because we fear sanction. And that's a sense of being obliged, like a burglar of a bank who has a gun to the teller's forehead. That notion of being obliged, the teller feels obliged to hand over the money because for fear of being shot. Hart is saying that that's not the case in society. We habitually obey the law because we have a sense of obligation to follow the rules. And so the correct way to view a law is from the internal point of view. it requires the reflective acceptance of a rule as being legally binding, as opposed to being afraid that we will face punishment if we disobey. Hart further divides obligations into legal and moral obligations. He says legal obligations generally result in sanctions. So if you can look up on the screen, there's all these different types of rules, but the way you distinguish legal rules is through the internal point of view. So for Hart, the ultimate legitimating standard is the rule of recognition, which distinguishes legal rules from any other kind of social obligation, including morality. So to the extent that law needs a necessary connection to morality, Hart agreed with his precursors in the positivist tradition. He denied any necessary connection between law and morality to establish validity. So Hart argues that the rule of recognition has no necessary moral content. It's just one that is recognized by the majority of legal officials who are responsible for imposing or establishing laws. Hart argues, however, on that point, that legal system must facilitate basic human survival and social harmony. And so it's necessary to a minimal extent that there be social acceptance of the rules that are considered law. This social coordination is seen as the minimum content of natural law. And so to that extent, he is soft as opposed to hard. He doesn't look just at sources, but he says that the sources have to be accepted by the society as a whole. It's still very impoverished view of what morality is, though. So his theory is still considered positivist because it merely defers the causative link between humans and the positing of the rule to a broader understanding of society and social coordination, and is mediated thus through a social test. That's the rule of recognition. It is still the product of human action. So without in any way denying Hart's theoretical brilliance, his social practice theory is, as you can see, well-reasoned. Let's identify a few major shortcomings. And one is the view that law is validated by social practice. Now, this fails to justify the reason individuals are under obligation in the first place. So the officials themselves. For example, why do judges have a sense of obligation to follow rules, moral rules? So whilst natural law is an open system, the positive framework is closed. And this is one of the problems, more broadly speaking, given the nature of the framework itself. So legal positivism must refer to standards within the framework of recognized sources for validity. If the system is fundamentally corrupt, it has nowhere else to go. So Lon Fuller criticized Hart's positivist theory because he believed it failed to account for situations where the system of law was bad, but also where the law itself was bad. Fuller argued that one should not view a law outside its purpose. So on this basis, Fuller argued for a necessary link between law and morality, and that law's authority stemmed from its conformity with that morality. Fuller's moral legal theory is thus referred to as a functional natural law theory, as his normative standards are based on procedural concerns rather than substantive. His natural law is based on what is required to make a law minimally functional, positing formal standards like that it needs to abide by a certain level of certainty, coherence, constancy, prospectivity to be a valid law. So Fuller's criticism of Hart culminated in the famous Hart-Fuller debate of the 50s and 60s, and that was basically Harvard versus Oxford. Another famous legal theorist who criticized Hart's legal theory was Ronald Dworkin. Now, Dworkin argued that Hart was incorrect about legal norms when he failed to consider what Dworkin refers to as the principles. Now, rules, he argued, characteristically apply in an all or nothing fashion, whereas principles have what we call this dimension of weight. And in reality, Dworkin argued that black letter law often runs out, and judges enter into this area called a penumbra of doubt, a space where the meaning of law is murky in its application to the given situation. So he's talking about unprecedented or novel situations occurring where the judges cannot just rely on black letter law, but have to appeal to principles in order to make a judgment. So in these cases, Dworkin argues that judges must have something to fall back on in order to fulfill their mandatory duty to adjudicate cases. Now, Dworkin concluded that judges fall back in these situations on what he called principles. And principles are the reasons for policy that exist in the backdrop of the law. Dworkin's contention was based on the rationale that Hart's theory is inherently closed to the possibility of anything outside the recognized rules as being relevant to the determination of what constitutes a law. If that is the case, he said, then what do we have to rely on when the rules run out? All right, so just to close this legal positivism video, let's look at some of the enduring influences that positivism has been responsible for ushering in. The positivist theories we discussed today are both a reflection, so a product of our times, as well as a response to our times. They have also left an enduring influence on the broader intellectual and cultural milieu. For one, Hart's soft legal positivism has served to reinforce the emphasis on quantitative data and functionalism in the study and the practice of law, and it has basically shifted the focus from the natural order of things to human innovative potential. So it's shifted the focus from the broader aspects of what constitutes a person, moral agency, our place in the universe, objective values in consideration of what a law is, basically from that to the mere function of law. All right. The effect of this inherently closed nature of the positivist framework itself renders it unwilling to engage in dialogue with other legal theories at all. And that's also problematic for the study of law. Legal positivism remains impervious to external influences. So broadly speaking, legal positivism's lasting influence has been to place a priority on human rationality, because it's about the source of law being determined by the human source of power, right? So it's based on an idea that all there is human rationality and human action in the construction and imposition of law. And so that extends to soft legal positivists who believe in a broader social order. It's still man-made. But what if human rationalism becomes distorted? Now, we know that human nature and human rational abilities are subject to error, fallibility. So what if the law that's codified becomes corrupted? Even if we defer to the social norms, are we always safe in the hands of, say, a rabid majority? Also keep in mind that the development of this legal theory has been occurring in a backdrop of the development of other philosophies and sociological movements. For instance, Darwinism and biological science encouraged functionalism and naturalism type thinking, as well as scientism, I guess. The idea that moral progress is the same as scientific progress. Also Nietzschean nihilism, the idea of the death of God, and that has been influential in the modern philosophical debates. And the rise of a Marxist theory of utopianism in the political sphere, which has encouraged materialistic behavior and humanistic behavior. So none of these forces can be viewed in isolation, but must be seen as working in synergy. So you have to consider the influence of legal positivism when it is seen to collaborate with these other forces which are lurking in the background. So on the upside, legal positivism has given us a sense of a more accurate understanding of what our legal systems are at a given time, what they can be, and some of the limits as well. A better understanding of the concept of law, how we as individuals and as a society contribute to its creation and operation. And that's been a positive contribution, right? But positivism, in the way it views the world, has cost us. It has cost us in giving us a framework for thought. It rejects any other mode of thinking about the law and the world around us. So this positivist exclusivism renders law as a self-contained system which rejects any other norm or norms as relevant outside this very narrow scope of reference. Regrettably, this rejection of justice norms in the backdrop of social culture has served to usher in this underlying movement of utopianism as an ideal. So what it created was, because it was so self-contained, and as a society, as human beings, we need to be able to appeal to something. As Dworkin said, that there are many instances where the rules run out. And in those instances, what do we appeal to? So humans have characteristically had to appeal to another standard, objective values, in asking these far-reaching existential questions. So what this means is that law has become instrumental to the achievement of social justice ends, for example, rather than being viewed on its own terms. So instead of the self-containment allowing the law to be studied in a more precise and accurate way, it's had this side effects of making the law a mere instrument to the achievement of another end, which now happens to be not so open and transparent. And we don't have an open and transparent debate about it because positivism itself quashes those debates or represses dialogue regarding other valid standards and norms to determine what the concept of law is. And so within that framework, there's this appeal to other things, but not in the sense that we're appealing to other things to determine what the concept of law is. It's just a wholesale use of the concept of law in order to achieve something else. And so Harold Berman, the story professor of law at Harvard University, wrote a short article in 1976 bemoaning this trajectory of legal education due to positivism. He warned about what would happen when the law abandons its origins, history, and normative foundations. And he begins by telling the story, a story which has become far too familiar in our modern time. So there was a student in Harvard Law School. During a class discussion, he asked, "But sir, is that just?" And his professor replied, "If it's justice you are interested in, you should have gone to the School of Divinity." So in my own personal life, I was told a similar thing at my graduate job interview when I responded to a question by the panel that inquired about the reason for studying law. And I replied at the time that I enrolled in law to learn more about justice. I remember the partner turned to me with this glazed look in his eyes, and he basically said, "Well, that's a pity because law is not about justice. It is about money." So when the law views itself as a self-contained system, it's no longer valued on its own terms, but in terms of its instrumental value to achieve something else. In the current cultural milieu, that appears to be social justice in that utopian sense of egalitarianism. In whatever way, whether that be in terms of money or utopianism, Berman concluded that once we stop asking questions about the law and its relationship to justice, its fundamental purpose, its historical, and then we stop studying its social development, what we are essentially doing is exposing our law schools to the dogma that the law is reducible to basically a few of its functions and nothing more. That is a lot to think about, but I think it's very relevant that we consider these issues and what happens in the future of legal education when this is the prevailing theory underlying everything we do. I don't foresee there being positive consequences if that is the kind of narrow view we wish to take. So I think it's important that we open ourselves to dialogue, as uncomfortable as that might be, because it requires us to critically think in real terms about the nature of the law itself and go back to the fundamentals. What is justice and what are the relationships between law and justice? If we don't have that conversation, we can never really move past a future where law is merely an instrument in the hands of whoever is in power at the time. So thank you very much for joining me again for another legal philosophy video. I hope to visit you soon with a few more. Thank you. Take care. Bye.